Very good evening to all the participants and the resource person, Dr. Betsy Vinolia Raja Singh. This is the 22nd week of our Know Your IP online uh, lecture series. And today we have with us Dr. Betsy Vinolia to speak to us on a very contemporary topic, namely the limitation and exceptions to copyright relating to educational use and overview. Before I request Dr. Betsy, it's my bounden duty to give a brief introduction. Here is a very proper IP scholar we are presenting to you. Dr. Betsy Vinolia is an IP academic and author, and she has a special research interest in the intellectual property laws, then internet law, and also technology, with special reference to social and economic development. She has a very impressive academic record, having obtained her Bachelor of Law from the Government Law College, Chennai, and she was the college topper there. After that, she proceeded to pursue her LLM in intellectual property and technology laws at the prestigious National University of Singapore as a merit scholarship awardee. Later, she joined a doctoral research program in Tamil Nadu Dr. Ambedkar Law University on the topic impact of digital technology on Indian copyright law with reference to access to education as a junior research fellow of University Grants Commission. And one of her famous books published by Thomson and Reuters in the year 2020 is the Digital Copyright Law, a comparative study of the limitations and exceptions to education. And she also has very good practical experience, having worked in both the countries, that is in Singapore and India, in the field of intellectual property law as well as practice, both. And today's topic is relevant to everyone because I personally feel that in India there is a prevailing opinion that we must behave like Robin Hoods as far as the information in public domain is concerned, especially relating to education and instructional purposes. So right from 1950s, when the second copyright law was enacted till now, there has been a long journey, and the impact of digital revolution certainly made its presence felt, and the law also has been changed after 2012 drastically. And there are a number of issues to be discussed, whether it is Rameshwari photocopying or Sci-Hub or many more. And I'm very sure that Madam will be covering all those areas. Now, I request Dr. Betsy Raja Singh Vinolia, ma'am, to kindly present her lecture. Over to you, ma'am.
Thank you, sir. Thank you very much for the very kind introduction and also for having me here. It's a delight to be able to present to this esteemed audience on intellectual property, especially in this Know Your IP series. Limitations and exceptions to copyright relating to educational use, a general overview. So to begin with, before starting as to what limitations and exceptions to copyright is, I will generally give a brief introduction of what IP is. So to begin with, what is IPR? We all know that the concept of IPR, it basically relates to creations of human mind that are protected by law. And it's broadly classified into two categories. One is the copyright and related rights. And on the other segment, we have industrial property. And under industrial property, you have patents, your trademarks, and designs, and GIs, and all of these. And under copyright and related rights, you have basically copyrights as well as rights for performers as well as for phonograms and rights for broadcasters. So this broad classification of intellectual property. And then if we look at WIPO's definition of what IP is, WIPO basically lists all these classified categories of intellectual property, the types, and then after they are talking about the typology, it says that It leaves the definition open-ended, saying that it also can include other rights that result from intellectual activity. So basically, with development, there can be new types of IP that are created, and even those are capable of being covered under the ambit of definition of what intellectual property is. So copyright is one of the predominant types of intellectual property. And if you look at what copyright is, copyright basically protects the rights that creators have over their literary and artistic works. This again is a WIPO definition, but if you look at our the Indian Copyright Act, the subject matter of what is protected as copyright, we will know that it protects literary works, artistic works, dramatic works, musical works, sound recordings, and cinematographic films as well. And again, just like the definition of IP, even the types of copyright is capable of being, with technological changes, copyright can cover new types of works within its definition. So because if you see, initially literary works consisted of lectures, your books, and sermons, for instance, but now it also includes computer programs. So similarly, even copyright can, with technological improvements, include many different types of works. For another example is like initially under artistic works, you just had paintings, you had drawings, but now artistic works includes photographs. And then with motion pictures and sound recordings, new types of copyright works began to be covered under the ambit of definition of what copyright is. But if you look at the Berne Convention, which is the first international convention relating to copyright, it talks about copyright to include literary, scientific, and artistic works. And I've listed a few examples of what copyright works are, which I've already discussed to you as well. Now, moving on, if we look at copyright and what can be protected as copyright works, we all know that copyright protects expressions of works and it does not protect ideas per se. This is called as the idea expression dichotomy. If you look at India, we have a very famous case law, R.G. Anand versus Deluxe Films, in which the Supreme Court basically, the facts of the case was, there was a play called Hum Hindustani, which was written by a playwright, and then it was also made into a film called New Delhi. Now, the broad idea behind this story, it's a love story between Madrasi and a Punjabi and how they get married, and it deals with provincialism in general. But the expression or the movie was made in a different way, and it wasn't a verbatim copying of the play. So when the playwright initiated the case, the court clearly said that ideas per se cannot be protected, but the expressions can be protected. The way in which the idea is expressed is what is protected under copyright law, provided it is original. So there is also this requirement for originality. Along with idea expression dichotomy, originality is also an important concept as to which basically tells you what work is capable of being protected under copyright. And when a copyright is granted to a person for his original work, which, as I said, can include any literary works, any artistic works, any movies, any songs, what is the rights that they get? They get a set of rights called as economic rights, which can be transferred. We will see in the next slide what the economic rights are, and also a set of moral rights that always remain with the author. And moral rights, it actually originates from the French tradition. And if you see, there are two types of moral rights, the right of paternity and the right of attribution. So basically, integrity and paternity, actually. Yeah. So these rights basically say that the authorship always will remain with the author. Nobody can change that. And similarly, a work can be protected against mutilation, and it is a moral right of the author. And also, you have the set of economic rights like the right of reproduction, the right of adaptation, which we will see in the next slide. So there is a set of rights that are given to the copyright owner for original work that has been expressed in an original form. And now, though this copyright law gives a set of rights, there are also something called limits and exceptions to this right. So copyright is not unfettered, right? It's not a right which is unfettered. It basically has certain limitations and exceptions. And the purpose for these limits and exceptions is to ensure that there is always a balance between the interests of the copyright owner and the public interest in access to works. We will understand this better as we move on to the next few slides where I will explain this better. So basically, what is this copyright balance? So a set of economic rights, as I already said, is given to the author or the owner of the copyright work. And these include the right of reproduction, the right of adaptation, translation, distribution, and communication to the public. Now, what is each of them? Right of reproduction basically says that, for example, if I write a book, I have the single right to make copies of the book. That is right of reproduction. And under right of distribution, the copies that I make, I have the single right to sell them. That is the right of distribution. And if I want to make a movie out of the story that I've written in the book, that is my right of adaptation. Similarly, I have right to translate as well as communicate to the public either over internet or other digital tools. So all these rights are a set of economic rights that the copyright law basically gives to the author of an original work of copyright. Now, this is on one side. And on the other side, as I said already, you have certain limits and exceptions. Now, these limits and exceptions ensure that this monopoly right that is given to the copyright owner is not perpetual. For example, the term of copyright is a limitation. So basically, in India, if a copyright is granted to an author of a work, it is for life of the author plus 60 years. So that is the term. So after the end of the term, the work falls into the public domain. So that is a inherent limit. Similarly, as I told you already about idea expression dichotomy, ideas per se cannot be protected, and that is also a limit. Only the expression can be protected. Similarly, you also have specific listed exceptions which are also listed in the statute. For example, in India, we have section 52 of our Copyright Act, which basically deals with a set of basically specific exceptions where people can use copyright works without prior authorization of the copyright owner. So these are for a list of specific purposes, like for educational purposes, for private study, for criticism, for all these instances that are listed in the Copyright Act. Basically, a copyright owner, without his authorization, the work can be used by the general public. And this is in interest of the general public. So the existence of this limits and exceptions is to ensure that there is a balance, because a set of exclusive rights is given to the owner. At the same time, there are also certain limits and exceptions for the benefit of the public. Now, this will ensure that there is a balance in copyright law. Moving on to the origin of copyright, I wanted to deal with this in particular because to understand that copyright is something which is relatively new. And if you look historically from the pre-modern period as such, knowledge was always considered to be a commodity which was given from God. So it was, if you see the Greek tradition, Hesiod's Theogony specifically talks about knowledge is coming from God. You have Islamic tradition, the Christian tradition, where the Bible or the Holy Quran basically says that all knowledge comes from God, and this knowledge should be capable of being transmitted freely to all people. It is also there in the Chinese tradition. So all these pre-modern ideas basically say that the concept of knowledge comes from God, and authors are merely acting as instruments in disseminating this divinely knowledge. So there was no concept of ownership of knowledge for individuals who actually write the works. For instance, the author of a work cannot claim ownership over it, and he cannot commodify it, because the knowledge that he was basically sharing with the people through his works was coming to him through God. And even if you see our Indian tradition, for example, you have a classical languages like Tamil, like Sanskrit, in which we have lots of literary works which have been in existence for a long, long time. And here again, there was no property element attached to this knowledge goods. And what it was considered, of course, these poets or court poets enjoyed royal patronage. Basically, kings ensured that they were taken care of, but there was no commodification of knowledge per se, and knowledge was freely distributed through the works that these authors wrote. So when did this concept of copyright as such emerge, if knowledge was always free and it was coming through God and you were disseminating it freely. When did the commodification of knowledge actually come about? That came about after the invention of the printing press by Johannes Gutenberg in the 15th century. So once printing press came into being and copies were capable of being made easily, then you actually see the beginning of copyright. Because initially when the printing came about, the first type of regulation that was available was by granting privileges. And these privileges were first granted in Venice to this person called Johann Speyer in 1469 for a period of 5 years. He was given this complete monopoly to print books in Venice. So there was privileges that was granted to him in exchange for state censorship. And this from Venice moved on to other parts of continental Europe as well as to England, where the first grant was given to a person called William Farquhar in 1504. He was in fact called the King's Printer and he had the exclusive right to publish all works in England back then. But then as printing began to kind of like increase, there were more number of printers, a guild was set up and the stationers company came into being in 1557. Now again, the system of privileges continued to be in existence. And in Stationers Company, what they actually did was when a work has to be published, they basically had this guild of printers. They had specific privileges and they started writing it down on paper and even trading them as permits. And if you see by the end of 1695, when privileges was finally abolished, there was a complete monopoly of printing in England. And in fact, there were 4 printers who basically monopolized the printing activity in England. And this led to definitely increase in prices because just 4 people were printing all of the books that were published in England. And readership also increased. And there was consequently an increase in price and lots of abuse of these privileges. So privileges was finally scrapped in 1695. And the first Copyright Act, the Statute of Anne, was enacted in 1709. If you look at the Statute of Anne, it was the first legislation in copyright. And if you see the philosophical justifications behind intellectual property in general and behind copyright in particular, you will see that Locke's philosophy is one major. His second treatise, in fact, is often cited as in defense of granting intellectual property rights. In fact, when the Statute of Anne was enacted, Locke's philosophy was used as a defense because in Locke's philosophy, he basically says that any person who invests substantial time and energy has to be rewarded for his labor. So the labor theory of Locke, wherein individuals who invest time, effort, create a work, write a book, have to be rewarded. Therefore, rights have to be given to these individuals who invest their time and effort and labor in creating a work. So Statute of Anne, for the first time, it vested something called copyright with the author. And the author for the first time became the owner of the, or herein begins the concept of actually commodifying intellectual works. The introduction that I basically gave you before the origin of copyright, I said that knowledge came from God, but here knowledge was the individual's. It was his property. And when property rights came to be attached to the individual through a statute, he basically had rights to commodify it, to commercialize it. And this is basically the first time copyright came about because it was vested with the author and he had the right to basically use the work that he created for his commercial purposes to get basically incentives out of it. And if you see the Statute of Anne, the very title itself, though it vests copyright with the author, it also says that this act is an act for encouragement of learning. So when it says encouragement of learning in its very title, you also see that there are provisions in Statute of Anne which particularly deals with limits and exceptions. Now, what are these limits and exceptions that were there in Statute of Anne, the first Copyright Act, with relation to access to copyright works? If you see, the Statute of Anne specifically stipulates that when a printer prints his books, some have to be deposited in the Royal Library. They have to be deposited in the universities, libraries of universities. And there was a term of 14 years, which can be basically extended to another 14 years, and the maximum term was 28 years, after which there was no more copyright. The work fell into the public domain, which means anybody could use it. And also there was a check on pricing, because there was a mechanism through which people could basically initiate a case against the law, a case to the Lord Chancellor, saying that books have been sold for exorbitant prices, and the Lord Chancellor could hear these claims, and basically he had the authorization to have a check on exorbitant pricing. And also it allowed for import of foreign books. Foreign books were allowed to be imported in England by way of the Statute of Anne. So all these exceptions were there in the Copyright Act, the first Copyright Act itself. But if you see the basic underlying idea behind the statute, though it came after the abolition of privileges, which was to check abuse by printers, in fact a set of a few printers, you see even the Statute of Anne was indirectly brought about by printers in order to retain control through the act. Because though the act for the first time vests copyright with the author is not somebody who is going to be printing the books. He invariably goes to the printers, so he assigns his right, and through assignment it's finally the printers who are publishing the book and getting incentives for out of it, making money out of it. And it is only a little amount or a fair share that they are sharing with the actual author. So if you see the act, though it has provisions specifically for limits, it talks about learning, the underlying idea is even the first Copyright Act was actually an indirect move by printers to retain control through the act. And if you look at international copyright law, so how did international copyright law come about? You know, the first Statute of Anne was, the first Copyright Act, the Statute of Anne, came about in 1709. It spoke about vesting property rights on individuals who were authors of the work. And basically it did speak about limits and exceptions, but also we also saw that it was indirectly a move by printers to ensure that their monopoly rights over printing was still secure. So if you look at international copyright law and how it came about, we all know international law, the primary purpose is to harmonize laws. It has to ensure that signatories meet the minimum obligations set out by international law. But if you look at copyright, it actually came about because of a single organization called ALAI, the International Literary and Artistic Association. Now, this was a private organization. And how did it move for the first international law on copyright, namely the Berne Convention of 1886? If you see in European countries, there was copyright law after the Statute of Anne. Individual different countries had different copyright laws, but it wasn't, there were significant differences in these laws between the countries. And also, if you see in the 19th century, after the Industrial Revolution, there was lots of increase in readership. When there was increase in readership, there was also consequently a rise in piracy. And if you see, the countries that were principally affected by piracy was England, France, and Germany, because most of the books printed in these countries were pirated in, for example, English books were pirated large scale in USA, and French books in Belgium. And if you see German books, other German speaking European countries engaged in piracy. So these three countries were largely affected because of piracy and because of the increase in readership. And therefore they set out to basically have bilateral treaties with these countries where their works were pirated. So even these bilateral treaties, over time, they were not sufficient to contain piracy. And therefore they felt that there was a need to bring about certain harmonized set of laws, namely the Berne Convention. And this came about due to the action of a private organization, ALAI. And this organization, the principal members were from these developed countries, namely England, France, and Germany, and they ensured that they brought about the Berne Convention of 1886. And if you look at the Berne Convention of 1886, as I already told you, it was brought about by this single organization, and it was instrumental, in fact. And similarly, you have many other copyright laws as well, but some of the most prominent, which are very, very relevant today, apart from the first Copyright Act, that is the Berne Convention, is the TRIPS Agreement and the Internet treaties, which includes the WIPO Copyright Treaty and the WIPO Performers and Phonograms Treaty. Now, there is one thing which is common for all these three international laws, which today regulate basically domestic copyright law as well. What is this common thread between these three agreements, apart from the fact that they deal with intellectual property, is the fact that all these three international instruments were brought about through concerted action of certain individuals. For example, as I already said, the Berne Convention was through ALI, which was a private organization. Similarly, if you look at the drafting history of the TRIPS for the first time brought intellectual property within the trading regime of the WTO. And how did this come about? Because you already had a specialized UN agency called the WIPO, which was the World Intellectual Property Organization, to regulate IP. So what was the need to bring IP under WTO? If you see, it was basically a concerted action of 12 multinational corporations from the USA. Actually, there is this book by Susan Sell, which clearly lists out and tells you the way in which these MNCs lobbied to bring about TRIPS and made sure it was under WTO and not under WIPO, to ensure that there was because TRIPS, unlike WIPO, because it was under WTO, there was also the dispute settlement mechanism, which made TRIPS enforceable, unlike the other international copyright laws. So therefore, if you see TRIPS was also brought about by MNCs. Similarly, if you see the WIPO Copyright Treaty, which basically is also called as the Internet Treaty because it assured digital copyright law. Digitization was first time introduced through the WIPO Copyright Treaty of 1996. It came about due to the concerted action of the Motion Picture Association of America. Basically, they wanted to ensure that their motion pictures were not pirated on a large scale in countries outside USA, particularly in developing countries. So they wanted stronger IP protection. So they bought anti-circumvention laws through the WIPO Copyright Treaty and WIPO Performers and Phonograms Treaty. So as I already said, the basic idea is like, though these three conventions are international copyright law, they came about due to lobbying of particular industries in developed countries. So though it is international copyright law which sets out um, uh, basic copyright laws and talks about minimum standard of protection, it is it is in fact directly because of action of the developed countries that these instruments came about. Now, what is the consequence of international copyright law coming basically because of the developed countries or the industries in them? It was basically to ensure that the interests of the copyright owners were secure. So this in fact means that international copyright law has come about. It's going to deal with the interests of the copyright owner per se. And what about the limits and exceptions which are there for the general public, for the public interest? They were largely relegated to the sidelines because, as I already said, international copyright law came about through concerted action of certain industries in developed countries, and therefore the primary objective or aim was to ensure that copyright was protected and these industries were able to reap profits out of it. So stronger copyright was the motive, whereas limits and exceptions were largely sidelined. So if you see the Berne Convention for protection of literary and artistic works, what does it say about limits and exceptions? As we already saw on the previous slides, it was through the ALAI, the Allied Berne Convention came about. It had the primary objective was to secure the interests of the publishers, and therefore did it actually speak about limits? Yes, it did. And what was the actual provisions with regards to limits and exceptions under Berne Convention? They were classified into three types. The first type is the limits with relation to subject matter. The second was the limits on economic rights. And the third one is the specific limits and exceptions. Limits with relation to subject matter is something that we already spoke about. The idea expression dichotomy, the requirement for originality. Now, this was a limitation with respect to subject matter. Similarly, limits on economic rights, definitely there was the term of copyright. We know our Indian copyright law stipulates that any literary or artistic work basically has a term of life plus 60 years. But Byrne says the minimum timeline that it provides for the term is life plus 50 years. Now, this is again a limit on the copyright that is granted to the copyright owner. Similarly, the Berne Convention did not define the right to reproduction or adaptation. Basically, this means it gave substantial leverage to national, to basically countries to enact copyright laws defining the right of reproduction and adaptation to basically to conform to their individual local needs. So it was not defined. So this is also classified as a limit. Similarly, there are specific limits and exceptions as well. And if you look at specific limits, there are compensated limits as well as uncompensated limits. Now, compensated limits, compulsory license is a standout example of a compensated limit. For even because through compulsory license, even if a license is granted, you still have to pay a set of pay an amount of royalty to the copyright owner. So it is a compensated limitation. At the same time, you also have uncompensated limitations like speech in legal proceedings, reporting of current events. This you can freely do without any authorization of the copyright owner. Now, these three types of limits are the Berne speaks about these three types of limits for copyright. And what exactly does it speak about education, which is our primary concern in this lecture? So what does the Berne Convention talk about in terms of exceptions or limits for basically educational use? If you see, there are two provisions. The first one is Article 10.1 and the second one is 10.2. 10.1, which talks about free uses for quotation, is a mandatory exception, which means it has to be member countries of Berne Union have to have this exception for quotation. But this exception for free use for quotation is qualified, which means the quotation should be available only from a lawfully made work. Similarly, the use should be compatible with fair practice, which means the quotation can't be huge. It has to be fairly reasonably small, and also the extent of the quote should not exceed that justified by purpose. For example, when do we use quotations from previously published works? We use it basically to either criticize it or to concur with it or to basically say something against it. So quotations as such can be used, but it has to be substantial, not exorbitantly. A large amount of verbatim copying was not allowed under Article 10.1. And the second educational related exception is Article 10.2, which is a permissive and not a mandatory exception. It talks about free uses for purpose of teaching. This was originally available as Article 8, but after the Stockholm revision. Now, this Berne Convention was revised subsequently a number of times, and one of the important revisions was the Stockholm revision of 1967. And during this revision, the Article 10.2 in its current form came about. And 10.2, if you see Article 10.2, which basically speaks about free uses for purpose of teaching, it talks, it says basically that a copyright work can be utilized to the extent justified by the purpose. And when can it be used? For teaching by way of illustration, provided such use is compatible with fair practice. Again, all these requirements are there. So there is this exception which basically says that for the purpose of teaching, a copyright work can be used without any authorization from the copyright owner. But again, this use should be by way of illustration, and it also should be for the purpose of teaching, and it should be compatible with fair practice. Now, what does this imply? For example, if there is a book which is published just for basically the primary audience are teachers and students, it is published for the purpose of teaching, then it wouldn't be fair practice to use that work on a large scale, because the work itself is published for teaching. Therefore, that cannot be on the whole used for under the exception, because that won't be compatible with fair practice. Similarly, it talks about utilization, which means not just the right of reproduction, but even other rights like today's right of communication to the public over the internet. All of these things can be done, which means a book which is published, you can make copies of it, that is using the right of reproduction. You can share it over the internet, and all of this is okay because it uses a broad term called utilization. And these are the two basic exceptions that are provided specifically under the text of the Berne Convention, which talks about educational use. And then we see that there is a very important test. Now, this test was fairly obscure initially because the three-step test, it came about after the Stockholm revision as well. And initially it was an obscure test, but today it's a very, very relevant test because TRIPS elevated its status. WCT also talks about the three-step test. And basically, as we already saw, the Berne Convention, the provisions specifically for limits and exceptions are as such minimal. And for education, you just have quotations as well as teaching use, which is again a limited use because there is not too much scope to use these exceptions. And these two exceptions, in fact, are further qualified by this three-step test. And if you look at three-step test, it basically tells you as to how a limitation or exception, or when a limitation or exception can be enacted in a national law. So basically, if a country wants to enact any limits and or exceptions, for example, India wants to enact certain exceptions for educational use, we have to comply with the three-step test. So it's an additional check. It is not per se a limitation or exception, but it is a control on limitation and exceptions. So though the Berne Convention talks minimally about limits and exceptions, there is this provision which in fact checks limits and exceptions. So when a member country wants to enact any exceptions, it has to be in conformity with the three-step test. And what does this three-step test basically stipulate? It says these exceptions have to be in special cases. And these special cases should not conflict with the normal exploitation of the work and should not unreasonably prejudice the interests of the author. So basically, when you are enacting a limitation or an exception, a specific exception in your domestic law, that exception have to conform to this test. Otherwise, it will be against the three-step test, and therefore it won't be lawful. So the three-step test is not just a check to ensure that domestic laws do not have very broad exceptions, but it's also a check for the judiciary. For instance, we will see later in the DU photocopy case, even judiciary can apply this three-step test to ensure or to check if a legislation which has a specific exception, whether this exception is permissible or not under international law. So Berne, on the whole, talks in a limited way about limits and exceptions, particularly for education. And additionally, you have this additional hurdle as well, the three-step test, which basically says that limits and exceptions have to conform with these three requirements. Now, if you look at what these three requirements individually mean, there is just one single WTO ruling, which basically speaks about the three-step test. And this ruling, in fact, applies the dictionary meaning. Now, we know that WTO law does not have the principle of stare decisis, and therefore it is not binding on subsequent judgments as well. But the singular interpretation that we have to this test is this ruling, which says that it basically applies the normal dictionary meaning and says that normal exploitation means basically an author would want to exploit his work to get monetary rewards or recompense. So he wants to make money out of it. So therefore, if you have an exception which is going to affect him making money by using his copyright, now that exception cannot be permitted, right? So it applies the plain dictionary meaning and says that any limits or exceptions specific exceptions per se, they should not stop the copyright owner or should not affect the copyright owner's interests, that is basically his ability to make money out of the copyright that is granted for his work. Now, after the Berne Convention, the next important agreement that I would like to cover in this lecture is the TRIPS agreement. I already said this was the first time that intellectual property was brought under the trading regime of the WTO. And basically, what does TRIPS speak about in terms of limits and exceptions? We see that TRIPS has no specific limits and exceptions. As we already discussed initially, TRIPS, as I said, was brought about through concerted action of 12 multinational corporations who wanted to bring stronger IP protection across the globe. They wanted to make sure that the intellectual property they were creating was um, unaffected, there was no piracy, and basically even in developing countries and least developed countries, they could still, which were their principal markets, they could make profits. So therefore they wanted IP under WTO, under the trading regime. And because it brought stronger IP protection, what it spoke about in terms of limits and exceptions for public benefit was very, very minimal, or I would rather say there was like no specific limits and exceptions under TRIPS with relation to um, basically to benefit the public. But TRIPS brought, or rather TRIPS actually, Article 1 to 21 of Bern applied to signatories of TRIPS as well. So basically, what are the two exceptions with relation to education that we already saw under Bern? It was the mandatory limitation for quotation and the permissive limitation for teaching uses. Now, these two, by way of incorporating the Bern provisions, Article 1 to 21 into TRIPS, were also applicable under TRIPS. So basically, signatories of TRIPS also had to have these mandatory limitation for quotation, and where they had a choice either to have the teaching exception or not. So apart from bringing Bern provision into TRIPS, making them operative under TRIPS, there was no specific limit or exception that was mentioned under TRIPS. And TRIPS also incorporated the three-step test. Now what TRIPS did was it enhanced, or rather what Bern provided as a three-step test, TRIPS actually made protection even more tighter, more stronger. Because if you see under TRIPS, the three-step test was applicable only with the right of reproduction. So basically, under three-step test, copies could be made using an exception if that exception confirms with the three steps provided in the three-step test. But here under TRIPS, all rights, basically all economic rights were applicable, and therefore even for other economic rights, for usage of other economic rights or usage of exceptions to ensure that you used other economic rights, again the three-step test was made applicable, not just to the right of reproduction but to all economic rights. And also in Bern, it specifically said that it should not unreasonably prejudice, the exception should not unreasonably prejudice the legitimate interests of the author. But here in TRIPS, it speaks about all right holders. So not just the author, even other right holders. For example, not just the author of a book, but the publisher of the book, to whosoever it is assigned. All of them should also not be affected because of these exceptions. So greater protection was provided for the copyright holder by way of TRIPS. And those Bern spoke minimally about limits and exceptions. TRIPS does not speak about it and also restricts it further because it enhances the three-step test, elevates it to a certain level, and basically this three-step test can be applied also to the mandatory limitation for quotation or the permissive limitation for teaching uses. Now, if under TRIPS greater protection is given, and even these minimal exceptions that were provided under Bern were further restricted by applying the three-step test, then you know that limitations and exceptions by far become very, very hard to use. Similarly, the next important treaty, the WIPO Copyright Treaty, and you know that it's also called as the Internet Treaties, the WCT and the WPPT. Now this ushered in basically digital copyright law, and it brought about anti-circumvention law. So basically, copyright works need not be secured in a, you know already that in a traditional medium, a copyright work, an author is given a set of economic rights, moral rights. He can use that work to make profits out of it. But in WCT, it ensures that this copyright is also extended to digital works. For example, a copyright work that is sold over or used on a digital medium, an e-book. So it can also be protected by way of technological protection measures. And if anyone breaks these technological locks, they will be liable under anti-circumvention law. And this anti-circumvention law was brought about through WCT. So copyright in the digital context, it brought about copyright protection, and it brought about additional protection as well through way of anti-circumvention legislation. And what does the WCT speak about in terms of limits and exceptions? We know that even there is no specific limit or exception relating to education under the WCT. It just talks about stronger protection for copyright works in the digital environment as well, but does not speak about limits and exceptions. And similar to TRIPS, Article 1 to 21 of Berne also applies to signatories of WCT. And similar to TRIPS, Article 10 of the WCT incorporates the three-step test. And the three-step test applies to limits and exceptions under WCT as well as limits and exceptions under Berne, which are incorporated in the WCT. So if you look at TRIPS and WCT as a whole, you will understand that limits and exceptions are by far non-existent, and even the very limited limits and exceptions that are available for educational use, namely the quotation as well as the teaching use, even that can be restricted by the three-step test. So on the whole, if you look at international copyright law in the context of developing countries, we will know that there are no positive provisions relating to limitations and exceptions in international law. And the three-step test further restricts enactment and usage of limitations and exceptions. And we also know that developed nations dictate global discourse on intellectual property, because international copyright law, or the principal instruments under international copyright law, namely the Berne Convention, TRIPS, and the Internet Treaties, came about because of lobbying of industries in developed countries. And therefore, copyright balance is also tilted in favor of copyright owners, because stronger protection for copyright owners consistently is provided in international copyright law. But there is no scope for limits and exceptions. And why are limits and exceptions significant to developing countries like us? Because we need access to works, right? And we will understand this better in the context of the Berne Appendix. Because if we look at international law, there is also this primary concern, or this primary thing that we've discussed already, that it came about because of concerted action of developed countries. Now, what were developing countries doing back then? Back then, we were still under colonial rule, and therefore, as colonies, we did not have any say in the negotiations that went preceding the Berne Convention of 1886. And India and other developing countries, which were also colonies, basically became members of the Berne Convention because our colonial masters made us do so. So when we gained independence, we had the option to walk out of Berne Convention. In fact, if you look at Indonesia, when after its independence from Dutch, they opted out of Berne, but India did not. Okay, and we did not opt out of Berne, and we still had Berne commitments. Now, why did we do that? And because if you look at India, it was very similar to USA after independence, because after the American independence, for almost 100 years, USA did not bring any copyright law, because they knew that stronger IP protection will not help them grow, because they were net importers of books from England. They did not have indigenous authors, or basically publishing was works from countries of basically works from UK. They were either imported and then published locally. So it was a situation very similar to India after independence. We did not have local publishing, large scale local publishing, and if we had had strong copyright laws, it essentially means that royalties will be flowing out of your country. So USA consciously made a decision not to bring about copyright law for almost 100 years after its independence, and this actually helped it grow, because what it did, it imported books from England. They could make copies out of it and sell it in USA, and without copyright law, there was no restriction on their sale, and there was also no royalties flowing out of USA. But India, because of local lobbying of a few reputed authors, we decided to stay with Berne commitments. We decided to not walk out of Berne, but have copyright law in our country as well. And if you look at the first copyright law, the Copyright Act of 1957, which came about after independence, we will know that there were actually lots of deliberations before the enactment of the act. For example, there was also this debate about whether we should follow the UCC and have only 25 years as term of copyright protection and not follow Berne, because Berne provided at least 50 years. So there was all of these discussions, but finally we decided to stay with Berne, and therefore we had Berne commitments, which made books in India costlier because we were net importers of books. We did not have much of local publishing, and therefore books became much costlier and access became much difficult in India. So if you look at the Stockholm Conference of 1967, which was a revision conference of the Berne Convention, for the first time all developing countries had a voice because they were all newly independent. They had their local needs. They understood like access was difficult. So India, in fact, spearheaded the moment for limits and exceptions to copyright with specific reference to educational use in the Stockholm Revision Conference. And if you look at the Stockholm Revision Conference, there was actually a African study group which preceded it, and then there was a meeting in New Delhi, and they actually had a draft protocol, a Stockholm protocol, which basically said that specific exceptions for educational use, in fact for bulk access of educational materials, should be provided for these newly independent countries, these developing countries, because we were in need of good education, and good education invariably relied on good source of learning materials. But we know that historically, though we spearheaded this negotiation for educational use of access to educational books, the Stockholm Protocol did not see the light of day, because basically developed countries ensured, or rather made sure, that they only provided a diluted, or rather very difficult provisions under the Berne Appendix for access to educational works. It was not what we originally asked, but was basically a compromise of sorts. And they basically allowed the Berne Appendix, which in fact came only after the Paris Revision Act of 1971. And what were these provisions under the Berne Appendix? The Berne Appendix, as I said, was a compromise solution, and it had provisions for compulsory license for translations as well as for reproduction for educational activities. But when you know it is compulsory license, you know immediately that it is a compensated limitation, which means it was not free use. So newly independent countries could not access materials that were much required for their local purposes without compensation. So they had to pay. So if you look at Ruth Toketji, who's a very good commendable scholar in limitations and exceptions, she basically sums it up very neatly. She says that by the time a developing country could make use of this compulsory licensing provision and get a right to reproduce or translate the work became no longer relevant. It became irrelevant because it took such a long time. And therefore, it was a very rarely used provision. It was rather an unused provision. So though developing countries made sure that their voices was heard, that their concerns were raised, and a solution was a compromise solution in terms of Berne Appendix was brought about, it was actually for no good, because nobody could make use of this Berne Appendix and increase access to educational works. So on the whole, if you see international copyright with reference to developing nations, as we already saw that international copyright do not have specific exceptions and limitations for educational use, and what is available is very limited. That is the exception for quotation, which is the only mandatory exception, and also the permissive exception for illustrations for teaching, which cannot be broadly used, as well as we see that bulk access to works, which is the need of the hour back then, because what we needed as newly independent countries was access to large amount of copyright works, because we were newly independent. We were not generating so much of books as we ideally would have wanted to. So we were reliant on imported titles, and these imported titles were expensive. So if we needed to provide quality education to our citizens, we needed bulk access of works. And this bulk access was not available because the Byrne Appendix, which came as a compromise solution, also made sure that nobody could use or make use of this bulk access to works through translations or even through reproductions because of its cumbersome procedural requirements. And then you also know that you have the three-step test, with basically limits the very limited exceptions that are already available, because it puts additional fetters or additional checks to have an exception for educational use or other use as well. So against this background, we know that international law and what how international law has panned out. And if against this background we look at how domestic laws, how countries as such have brought about education exceptions, we can begin with the concept of fair use. So fair use is something which um, basically is a specific exception. So already when we spoke about limits and exceptions, we said that limits include term of copyright, a specific term, the idea expression dichotomy, inherent limits. Also, there are specific exceptions like exception for quotation, which is available under Berne Convention. Similarly, individual domestic countries could also have specific exceptions. These are called fair use exceptions. Now, how did fair use come about? Now we have statutory fair use exceptions. For example, in India, we have fair dealing exceptions under Section 52, which basically has a list of exceptions which we can use basically to use a copyright act, or rather unauthorizedly access a copyright work and use it for certain listed purposes. So it had an enumerated list of exceptions under Section 52, which is very similar to the Copyright Patents and Designs Act of UK, which also has an enumerated list of exceptions. Now, if you see US, they do not have a list of exceptions. What they have is a factor test. And this factor test basically evolved from the case of Folsom versus Marsh. Now, Folsom versus Marsh was a case which dealt with basically the letters of George Washington, the first president of USA. Basically, his letters were previously published as a compilation. Now, subsequently, a person extracted more than 340 pages of that previously published work, and he published a biography. Now, the plaintiff raised a case before the court saying that there was verbatim copying of more than 345 pages, and that could not amount to fair use. That was basically infringement of copyright. And Justice Story, when deciding Folsom versus Marsh, he basically listed a four-factor test and said that the usage of 340 pages verbatim from a previously published work definitely is not fair use, and he listed the four factors. Today, that four factors enshrined under Section 107 of the US Copyright Act, which basically says that when a use is fair or not. So, for example, for teaching purposes, I use a certain amount of pages from a previously published book. When can it be fair or not? Basically, if it fulfills the four factors, then it can be fair use. Otherwise, it will not be fair use. And these four factors basically talk about the purpose and character of use, the nature of the copyright work that has been used, and also the amount and substantiality of the portion that is used, and the effect of the use on the potential market for the copyright owner. So, based on these four factors, any use can be considered as fair or not, including educational uses. And also you have specific provisions as well, two provisions, Section 110(1) and 110(2) of the US Copyright Act, which talk about teaching exceptions. In fact, Section 110(2) Clause 2 talks about exceptions in the digital environment with reference to distance education. It's also called as the TEACH Act. So apart from the factor test, also specific provisions for educational uses provided under USA. Moving on to India, if we see what are the provisions in Indian Copyright Act which specifically deal with educational exceptions. If you see, we have a few provisions under Section 52 which deal with educational exceptions. The first one, or the most principal one, is Section 52(1)(I), which basically talks about use in the course of instruction. Now here, the reproduction of any work by a teacher or a pupil in the course of instruction or as part of questions to be answered in an examination or in answers to such questions is permitted as fair use. It's a fair dealing exception for educational use. And therefore, there is this very broad exception, because here, unlike the US factor test, we do not have too many restrictions. Because the provision does not say as to how much can be copied, how much cannot be copied. There is no reference to the amount that can be copied for instructional use, and also basically it is very broad. So when this DU photocopy case came before the courts, where a photocopy shop in the Delhi University, Rameshwari photocopy shop to be more precise, was sued by Oxford University Press, Cambridge University Press, and Taylor and Francis, three leading publishers of academic books. They sued them for copyright infringement for publishing of their course packs. They relied on this exception, and they said that basically under this exception, for the course of instruction, we could make use of already published works in which copyright subsists without the authorization of the copyright owner. For educational use, we can take excerpts and compile it and use it for educational purposes. So in this case, we know that Justice Endlaw in the single judge bench in the Delhi High Court, he basically said that whatever Rameshwari photocopy shop did was fair in fact, and therefore no infringement of copyright. Now this went on to the division bench, and we all know there was substantial amount of in fact, it raised a lot of eyebrows across the country, and there were lots of academicians who were writing to the publishers, and finally they withdrew the case. But if you look at the case as such, it actually highlights the fact that if you read the Copyright Act, the letter of the law, maybe if you apply the three-step test, you will see that this copying of, or rather taking of excerpts for the purpose of educational use may not be permissible as such, because if you have to be in conformity with international copyright law and the three-step test that is stipulated by Byrne and Trips and also WCT and WPPT, you will know that, or you can see that even for educational use, you cannot do large amount of copying from previously published books, because that can amount to copyright infringement. So what our courts did was a good thing, because they ensured that we as a developing country needed access to works, we need access to information, and therefore we could not basically say the students couldn't principally buy books because they were exorbitantly priced, and therefore to ensure access, publishing of course packs is permissible, and therefore whatever Rameshwari photocopy shop did was in fact lawful. So that was a very liberal interpretation of the courts. But if there was a strict interpretation of section 52(1)(I), you would you can very well come to a contrary decision as well, especially with international law, that such large scale copying from previously published works may not be actually permissible in India. So what the courts did was a good thing. And also, if you see other provisions in Indian domestic law with reference to educational exceptions, you have 52(1)(H), which talks about anthologies for instructional use, but this basically talks about out of copyright material. So how much it can be used, because if you talk about educational access, what you need is current relevant works, and out of copyright material essentially cannot have very current and relevant educational materials per se. So it cannot be on the whole used for educational purposes. And also you have related rights, not specifically with relation to education, but related rights which can be used for educational purposes, such as fair dealing for private use, for private study, library use. And also we have access to blind and visually impaired or print disabled persons. So exceptions for all of these is available under the Indian Copyright Act, which can be related to educational use as well. So apart from these fair use provisions, what other limits and exceptions can be used for educational use? There is this concept of copyright exhaustion. Now, copyright exhaustion, which is also called as the doctrine of first sale, essentially means that For example, I buy a book from a bookstore. The copyright owner's right over the copy that I just bought ceases to exist, because the copy that I bought, the copy of book that I bought from the shop is mine, and I can resell it or do with it whatsoever I may wish. So basically, the copyright owner's right over the copy ceases with first sale. And exhaustion, this is copyright exhaustion, or the doctrine of first sale. And this can be classified into three types of exhaustion, that is national, regional, as well as international exhaustion. And international exhaustion primarily means that parallel imports is lawful. Now, what is parallel imports? Parallel imports is basically a concept where books can be imported from countries outside India and sold in India. Now, what is the necessity, and why should books be imported from outside in India and sold in India? If you see, there is this concept of price arbitrage. For example, a publisher, a reputed publisher, a foreign publisher, may publish his book in India for say 750 rupees, and the same book may be published in Indonesia on cheaper quality paper for 500 rupees. Now, using parallel importation, if parallel importation was lawful, basically anyone could import the books from Indonesia, buy it for 500 rupees, 100 copies, import it into India, and then resell it here for 600. That is nevertheless lower than the MRP for which the book is sold here, namely 750 rupees. So using this price arbitrage, basically it can increase access to published works. So this is this concept of parallel importation, and this is lawful when a country recognizes international exhaustion. So if you look at exhaustion, what does international law say about exhaustion? If we see, it actually does not say. It gives complete discretion to the member countries to have any provision regarding exhaustion. So it does not stipulate anything, and it is by far unregulated. So if you look at Indian law, our section 14, there is actually no clarity as to whether we are following international exhaustion or national exhaustion. The courts so far have decided that we follow national exhaustion, which means parallel imports is not lawful in India. And to basically set this right, we had an amendment proposed as well, section 2M, to ensure that there was clarity, there was legislative clarity that India recognized parallel imports. But due to lobbying, in fact, in the Jaipur Literary Festival, during that time, Kapil Sibal was the minister back then, and due to intense lobbying, this section was finally dropped from the Copyright Amendment of 2012. So if this section was amended, international exhaustion and parallel importation would be lawful in India by now. But again, due to lobbying from publishers, it was dropped. And even after dropping this amendment, there was this NCAR report which was commissioned to see if we needed parallel imports or not. And this committee basically gave the report saying that it was completely in favor of international exhaustion. And why? Why so? Because basically, if you look at books that are published in India, say educational books are principally for the basically for educational use, especially in higher education segment. Because if you look at access to books, you know that India, basically in school education or so, we do have a state publication. The state basically publishes books, and we also, because of our human rights obligations as well as our constitutional obligations for compulsory education up to 14 years, we have ensured that the gross enrollment ratio in schools have been consistently high. So we have been like more than 90% in terms of school education, the enrollment. But there is a sharp drop after moving out of school. If you look at tertiary education, college education, you know that from the 90% or so, which is the enrollment ratio for schools, it drops to 24% for basically college education. Why is this huge drop? Because we know that in terms of education, school education can be, or rather is provided by the state, and because of its obligations, there is free and compulsory education. So students get at least functionally literate, and there is no dropouts in the school level. But once school on completion of school education, there is a sharp drop because higher education segment is mostly, though we have state funded educational institutions, there is a large amount of private parties who are also involved in the education market in the higher education segment. Therefore, higher education has such becomes costlier. And if you look at learning materials, apart from the fees and everything, the books that students have to buy, that is becoming costlier too. Why? Because this report clearly says that in India, for educational books alone, the publishing of educational books, almost 72% is imported titles. So though copyright, basically the publishing industries say that you should not allow parallel importation, we should have local publishing, because local publishing means there is more jobs, there like more access to books. So we want to ensure local publishing and therefore don't legalize parallel imports. But what is actually true and what statistics tells us is that local publishing is very, very minimal. Since 2000, we have allowed foreign direct investment in book publishing for publishers from outside India. But what they do is more than 72% they import and sell, which means they do not basically print here and sell. So which means these imported titles are definitely costlier. So access becomes an issue, and especially for any higher education, including professional degrees. Good quality learning materials is one of the principal sources of good quality education. And this education material becomes very, very difficult for students to access because they are very costly. In fact, even some institutions cannot access many of the books for their libraries because they are very, very highly priced and imported titles. So therefore, if we have parallel importation, that is one way of basically making access more easier, because second-hand bookstores can import from outside the country and sell for cheaper rate. But then that is also basically there is no clarity today because of lobbying from the publishing industry. And the last part of this presentation, I would like to talk about digital copyright and limits and exceptions. We already, what we've seen so far is that limits and exceptions are by far few, and unlike stronger protection for copyright in international law, they are very few. In domestic law, yes, there are provisions, but how far those provisions are used, again, there is a check through the three-step test. And therefore, countries have to make sure individually, like our DU photocopy case, we have to ensure that we provide means for access to copyright works by liberal interpretation of our educational exceptions. And also we saw about the concept of exhaustion, which is again not regulated under international law. And if we say take the Indian example as well, though it is wiser for us and good for us if we have parallel imports, till now we do not have any legislative clarity because of again lobbying from publishing industries. And finally, Digital Copyright Act, which basically what I would like to focus and say is that the technological protection measures and the anti-circumvention law that the Digital Copyright Act brings about, that the WIPO copyright treaty, and through it in India, for example, through our copyright amendments of 2012, we brought about section 65A and 65B. 65A particularly talks about technological protection measures, which means any locks that can be used to lock up copyright content in a digital medium. So for example, an ebook can have um, an access control mechanism, like you have to have a password protected entry into that system to access your ebook, or you have scrambling techniques or encryption techniques that are used on CDs. So all of these TPMs additionally are an additional arsenal for the copyright owner, because apart from copyright law, they also have technological tools that ensure that their works are protected in a digital medium. And when you have these technological tools, what happens to fair use, or what happens to first sale? Can an ebook be exhausted? Can it be resold? Similarly, you can legitimately take a book, make a few copies of a few pages, use it for educational use. But can you print copies of an ebook? All of this becomes very, very difficult because there are not only technological locks, but if you break these locks, you will again be liable under anti-circumvention law for copyright infringement. If you look at the Indian provision, we are fairly less stringent in comparison with the Digital Millennium Copyright Act of the USA or the EU Copyright Directive. Our law is fairly less stringent because what we have is only copy control mechanisms. We do not have access control mechanisms, which means if an ebook, you break a lock, in USA, the moment you break it, whether you infringe copyright or not, you will be liable. But in India, only if copyright is infringed, that is, the economic right of the copyright owner is infringed after you break the lock and use the content, only then you will be liable. Nevertheless, even though the provision is less stringent, how far a person can make fair use of a copyright work for educational purpose is again questionable, because for example, a teacher who might want to access an ebook and circulate certain excerpts from it might not be able to do so because he or she does not have access to circumventing technology. And also, basically, even if it's accessed, it cannot be communicated to the public under section 52(1)(I), which is the education exception in India, because section 52(1)(I) specifically talks only about right of reproduction. It does not talk about communication to the public. So even the law, Indian section 52(1)(I), to accommodate fair use exceptions in a digital context have to be amended, because if it's going to deal only with the right of reproduction, it essentially means that in the digital context, this exception cannot be used at all, because even though you take, if you access a copy circumventing the technology, you cannot circulate it online to your students using your email or your IVLE technology, basically because the right of communication is not provided under Article 52(1)(I). So there are these legislative lacunae as well, and the law has to be amended to accommodate fair use and first sale in the digital context as well. So in conclusion, from this lecture, the principal takeaway that I would like to suggest is that strong copyright protection, be it under TRIPS or under WCT, basically is through lobbying from developed countries, and they lobby under the premise that strong copyright protection incentivizes creation of future works, but it is not always true. And we know that being developing countries or a least developed country for that matter, what we need is access to good quality educational materials, and this can be made available only if copyright is balanced with adequate limitations and exceptions to copyright. And though international copyright law does not provide ample leeway for limits and exceptions, we would have to ensure that we use the flexibilities that are there in this international provisions and enact fair use provisions within our countries to ensure that fair use are not just used as defenses but as in fact user rights. In Justice Endlaw's judgment of the DU photocopy case, this was precisely one of the things. He considered 52(1)(I) not just as an exception or a defense. Basically, he considered it as a right. So every student or every teacher had a right to make use of these provisions to ensure that there was access for lawful purposes such as educational use. And also, as I already said, parallel importation has to be legalized, because if you look at the broader picture, we know that local publishing is minimal, and basically foreign publishers, who are the majority publishers in our country as well, import and sell books for a costlier price. They do not publish locally. So we have to ensure that even parallel importation is permitted so that books are available for cheaper price and access becomes easier. Thank you.
Thank you, ma'am. Thank you so much, ma'am, for such a elaborate session. Now I would like to request the chair professor, Professor G.B. Reddy sir, to please continue with the proceedings.
Thank you very much, ma'am, because for the last 1.5 hours, you have been continuously trying to explain various things, and in fact, it's really impressive. Thank you very much. Now it's over to request Mr. Srinivas Rao to propose a formal vote of thanks. Thank you.
Thank you, sir. Thank you, ma'am. On behalf of DPIIT IPR-Chair OU Hyderabad, India, I would like to take this honor to host vote of thanks. Madam, first of all, thank you for sparing your time for this session and joining us the moment of dissemination of information to everyone in intellectual property. So you have explained a few rights related to copyright, which are on top of the fundamental rights as available to us under the Constitution of India. So you talked about the chronology of events that happened in the terms of copyright legislation, and you also talked about the international copyright law. So you talked about ALAI, International Literary and Artistic Association, which was instrumental in Berne Convention 1886. And you also mentioned that the major instruments which are evolved are due to the interest of copyright owners who are not part of any government or related to any of the government organizations. So this gives a pointer that if you have a strong foundation or base for change, you can be a change maker. Man, last week we had a session on plagiarism, and the resource person, just to make us aware, like what are the checks that are to be done at the back end and modus operandi of the authors to escape plagiarism. He made a presentation in a very detailed way. So your lecture can be treated as a continuation to the previous session, where the viewers can now be little relaxed based on few exceptions which you talked about. You summarized all the international events and touched upon decolonization, Stockholm Convention, compulsory licenses, doctrine of fair use, first use, and many more. Ma'am, your session was also helpful for the participants and viewers to do the qualitative research from this time onwards. So I would like to thank you for being here and apprising us on the topic. I would also like to thank the active participants for their energy, enthusiasm, and the organizing team for being the continued audience for us. So thank you for attending this session and posting some of the interesting questions. So before leaving, participants, please ensure that you have subscribed to our Telegram channel and the YouTube channel as well to get the regular updates on the lecture series and the PPT, which is in the most demand. You can view all our past lectures as well, which are related to Know Your IP, DPIIT, IPR-Chair, OU, Hyderabad, India. So with this note, ma'am, and to hope you see you again once again. Until next week, we will take leave as of now. See you again. Thank you, ma'am. Thank you, sir.
Thank you, sir. Thank you.
Thank you.